Wednesday, DOJ just dropped the entire antitrust case against TechCore. Not settlement. Dropped. Dismissed with prejudice. According to internal memo leaked at 4:17 p.m. Evidence obtained through illegal surveillance. I've got the 23 pages. Page 14 shows FBI access servers without proper warrants for 18 months. Here's what they're not covering. Page 19. The lead prosecutor knew about the warrant problems in February. Proceeded anyway for 7 months. That's the memo, not speculation. But that's not the worst part. The evidence they collected illegally, it's also being used in 12 other active cases against tech companies. All those cases now in jeopardy. Friday at noon, emergency hearing. Judge decides if those cases survive. Clock's running, let me show you. Quick context. TechCore, cloud infrastructure company, $340 billion valuation. The issue, DOJ claimed monopolistic practices in enterprise cloud services, blocking competition. Timeline fast. 3 years ago, DOJ investigation begins into market dominance. 14 months ago, criminal charges filed, TechCore CEO indicted. Today, case dismissed after leaked internal memo exposes illegal evidence collection. That's the setup. Now, what's in the memo that everybody missed? This wasn't a whistleblower doc from TechCore. This came from inside DOJ. Deputy Assistant Attorney General Rachel Kensington wrote it to the Attorney General. Subject line: critical Fourth Amendment violations in TechCore investigation. Dated August 8th, 5 days ago. She sent it Monday. By Wednesday, it's on ProPublica. Someone inside DOJ leaked their own memo exposing their own illegal tactics. That's internal rebellion. Now, what's in Kensington's memo that networks missed? The memo. Page 3. FBI Cyber Division accessed TechCore's internal servers 247 times between January 2025 and June 2026. Direct quote. Without warrant authorization for 193 of those accesses. That's illegal search and seizure. Page 7. Lead prosecutor Michael Chen was briefed February 14, 2026 that warrants were defective. Advised by FBI General Counsel that FISA court would likely rule inadmissible. Connects to the first one. He knew in February the evidence was poisoned. Trial started in May. He used it anyway. Gets worse. Page 11. The anonymous tip that launched the investigation in 2023. Numbers. Came from FBI contractor who was paid $340,000 as informant. That contractor, former TechCore employee fired for cause. Revenge motive documented in FBI vetting file. 3 findings. Same pattern. Warrantless surveillance for 18 months. Prosecutor knew and proceeded origin based on paid informant with grudge, all documented. Pages 3 to 14. But wait, page 16 shows the surveillance tool FBI used was provided by Israeli firm CyberTrace. Same tool declared illegal in EU courts last year. That's not standard law enforcement. That's foreign spyware banned in allied countries. Timeline proves intent. January 2025. Surveillance begins with CyberTrace tool February 2026. Chen briefed on warrant defects May 2026. Trial proceeds using tainted evidence 17 months from first illegal access to trial. Planned. The kicker, page 18. Kensington's analysis. Fruit of poisonous tree doctrine applies. Not only is TechCore case compromised, every case using evidence derived from this surveillance method must be reviewed. She's not just saying TechCore walks. She's saying the entire FBI cyber investigative method for the last 2 years is constitutionally suspect. 12 active cases listed in Appendix C. Google, Meta, Amazon, Microsoft, Apple, ByteDance, NVIDIA, AMD, Oracle, Salesforce, Adobe, Palantir all use the same surveillance method, all potentially compromised. Subscribe, more documents dropping on this. Wednesday, 11:34 a.m. Here's what happened. Federal Judge Sarah Blackwell issued order from the bench. Middle of testimony. Stopped the trial cold. This case is dismissed with prejudice, effective immediately. Prosecutor Chen stood silent for 11 seconds. Cameras caught it. Immediate consequences. TechCore stock surged 34% in 22 minutes. Attorney General announced internal review at 1:47 p.m. 3. FBI officials placed on administrative leave by 3:15 p.m. 4 hours. That's how fast this moved. While everyone focused on TechCore's stock surge, Judge Blackwell issued sealed order to DOJ, requiring disclosure of all cases using CyberTrace surveillance tool. Sealed, not public, but docket entry shows order exists. That's evidence preservation mode. She's preparing for more dismissals. Attorney General's response: called emergency meeting with FBI director at 2:33 p.m. That's documented in White House press pool reports. This isn't damage control, this is crisis management. By 5 p.m., Senator Elizabeth Warren issued statement calling for congressional investigation into systematic Fourth Amendment violations by law enforcement. Republican Senator Josh Hawley joined her an hour later. Bipartisan fury. When Warren and Hawley agree, someone's in serious trouble. TechCore CEO David Park, who'd been facing 20 years in prison, held press conference at 6:47 p.m. Not celebration, anger. Quote, "For 3 years, they destroyed this company's reputation with evidence they knew was illegally obtained. They knew in February. They proceeded to trial in May. That's not pursuit of justice. That's persecution. He's not letting this go." By 8 p.m., TechCore's general counsel filed federal civil rights lawsuit against DOJ seeking $47 billion in damages. That's on offense now. This changed everything. The DOJ wasn't just pursuing a bad case. They were knowingly using illegal evidence. And someone inside their own ranks couldn't stomach it anymore. Like, if you're seeing what I'm seeing here. Here's what nobody caught. Appendix B shows this wasn't Rachel Kensington's first warning. She sent preliminary memo to DOJ Inspector General in March 5 months ago. This wasn't in news coverage. This is documented escalation. The connection. March, Kensington warns Inspector General about warrant problems. April, IG opens preliminary inquiry. May, trial proceeds anyway. August, Kensington goes nuclear with memo to Attorney General. She tried internal channels. They ignored her. She escalated. Numbers tell the story. March 23rd, first warning. Sent April 8th. IG acknowledges receipt May 6th. Trial starts anyway August 8th. Final warning to Attorney General August 13th. Memo leaked to press 4.5 months between first warning and leak. Someone sat on this while the trial proceeded. Why this matters. This isn't whistleblower exposing corruption. This is senior DOJ official documenting that her own department ignored legal warnings to pursue a politically high-profile case. Not FBI gone rogue. DOJ leadership knew and proceeded. Former DOJ Inspector General Michael Horowitz confirmed that if IG received warning in March and trial proceeded in May, that's institutional failure at leadership level. Quote, "Preliminary warnings from senior attorneys aren't ignored accidentally. That's decision-making. That's independent verification from former DOJ watchdog. This changes the narrative from FBI overreach to DOJ knowingly prosecuted case with tainted evidence. The leak wasn't revenge. It was last resort. Kensington tried to stop it internally. When that failed, someone, possibly her, made sure the public knew. How we got here. 3 years ago, congressional pressure on DOJ to pursue big tech monopolies intensifies. 2 years ago, FBI Cyber Division given expanded surveillance authorities under classified FISA interpretation. 14 months ago, TechCore indictment announced with much publicity AG called it landmark antitrust enforcement. Quote from back then, Senator Hawley at hearing, "If DOJ doesn't have the tools to prosecute these monopolies, Congress will give them those tools." What happened? DOJ felt political pressure to deliver high-profile tech case. FBI used questionable surveillance method to build evidence. Prosecutors proceeded despite internal legal warnings each time. Political incentive overrode legal caution. Until Wednesday, Judge Blackwell rejected the government's motion to exclude Fourth Amendment challenges from trial. Once she allowed that defense, the House of Cards collapsed. She reviewed the surveillance authorization in camera, saw the warrant defects, dismissed immediately. What broke the pattern? A federal judge willing to actually scrutinize FBI surveillance methods instead of deferring to national security claims. Blackwell was appointed by Obama, confirmed 97,002. Impeccable credentials. Even she was shocked by what she saw in those classified authorizations. Stay with me. What experts are saying changes this. What experts are saying. Former federal judge Andrew Napolitano, 22 years on bench. Dismissal with prejudice means government can't refile. Case is dead permanently. Translation, TechCore can never be prosecuted for these charges again. Double jeopardy attaches. Constitutional law professor Orrin Kerr Stanford, Fourth Amendment specialist. If CyberTrace tool violated EU privacy law, using it domestically likely violates Fourth Amendment. Keyword, likely. Means other cases using this tool are vulnerable to same dismissal. Even former Attorney General William Barr, known for supporting law enforcement. If prosecutor knew evidence was tainted and proceeded, that's ethical violation minimum. When even Barr criticizes DOJ prosecutors, the misconduct is severe. Consensus. Warrantless surveillance for 18 months is flagrant constitutional violation. Proceeding after February warning is prosecutorial misconduct. All 12 cases using same method are now in jeopardy. That's professional analysis, not spin. Former FBI General Counsel James Baker. FBI has been using CyberTrace type tools for years under classified interpretations of FISA. This leak forces public scrutiny of secret surveillance. Former ACLU attorney Jamil Jaffer. This confirms what privacy advocates warned about law enforcement normalizing unconstitutional surveillance when targets are unpopular. National security law professor Bobby Chesney. The 18-month timeline suggests systematic program, not isolated mistake. Former DOJ Inspector General Michael Horowitz. When internal warnings are ignored and cases proceed, that indicates institutional priority, misalignment winning cases prioritized over constitutional compliance. Tech antitrust expert Tim Wu. Regardless of TechCore's actual market practices, prosecution built on illegal surveillance undermines legitimate antitrust enforcement. Former NSA General Counsel Glenn Gerstell. Use of foreign surveillance tools domestically without proper authorization. That's the kind of thing that gets programs shut down permanently. Different backgrounds. Same conclusion. This wasn't error. This was pattern. Fair counterpoint. DOJ officials speaking anonymously say surveillance was authorized under classified FISA court interpretation. Their case. CyberTrace tool was approved for counterintelligence purposes, TechCore investigation, involve potential Chinese government coordination. National security implications justified broader surveillance authorities. Former FBI Director Robert Mueller. Cyber investigations require sophisticated tools. Perfect warrant compliance isn't always possible. That's legitimate. What they have? FISA court did authorize some level of TechCore surveillance. Chinese government connections were part of original investigation. Even civil liberties attorney admits, if genuine national security threat existed, surveillance standards differ. But Kensington's memo specifically states 193 of 247 accesses lacked proper authorization. That's not imperfect compliance. That's 78% illegal access rate. And page 9 shows the Chinese government angle was dropped from the investigation in June 2025. Yet surveillance continued for another year. Both sides have arguments. Documents say DOJ abandoned national security justification, but continued surveillance anyway, then use that evidence in a purely domestic antitrust case. That's not protecting America. That's mission creep. Like, if this breakdown is useful, why this matters to you. If you use cloud services for work or personal data, your information might have been in that surveillance dragnet. Numbers. TechCore hosts data for 340 million users globally, 127 million in the US. Your privacy. When FBI accessed TechCore servers without warrants, they accessed everything on those servers, including your files. The precedent. Next time FBI investigates a tech company, your data on their servers is potentially accessible without warrant. Example, you run small business. You use TechCore cloud storage for customer data, financial records, communications. FBI investigates TechCore for antitrust. No warrant specifically for your business. But when they access TechCore's servers, they see your data too. They copy it. They search it for keywords. You're not suspected of anything. But your business records are now in FBI database because you happen to use the same cloud provider they were investigating. No warrant, no notice, no legal remedy. Who gets hit? 340 million TechCore users whose data was potentially accessed. Class action lawsuit filed Wednesday already has 47,000 members. Bottom line, if you've used any major cloud service in the last 3 years, assume law enforcement has accessed your data without warrant at some point. What people are doing. Reviewing cloud provider terms about government data requests, moving sensitive data to end-to-end encrypted services, knowledge helps. How DOJ responded made it worse. Attorney General issued statement Wednesday evening, defended the investigation. Quote, our prosecutors acted in good faith based on available legal guidance. Reaction. Judge Blackwell issued rare public statement calling DOJ characterization inconsistent with facts presented in camera. 6. Former DOJ officials published open letter by Thursday morning criticizing leadership. Senator Warren responded, good faith doesn't ignore internal legal warnings for 7 months. Then, Thursday morning, DOJ announced Michael Chen removed from Public Integrity Section, reassigned to Civil Division. Not fired, reassigned. Judge Blackwell's response. Ordered DOJ to preserve all communications between Chen and FBI regarding warrant authorizations. She's investigating if there was coordination to hide the constitutional problems, not de-escalating. Each defensive statement from DOJ prompts harder questions from Congress. House Judiciary Committee announced hearing for August 27th, subpoenaed Rachel Kensington, Michael Chen, FBI Cyber Division Chief, and the Attorney General himself. All four must testify publicly. Meanwhile, TechCore isn't waiting. CEO David Park announced Thursday afternoon company hiring 20 additional attorneys focused solely on civil rights litigation against federal government. Quote, "We're not just defending ourselves anymore. We're going on offense against every agency that participated in this constitutional violation. They're suing FBI, DOJ, NSA, and the individual agents who conducted warrantless searches to $47 billion in damages sought. Discovery in that case will expose every surveillance tool and method FBI used. DOJ's nightmare scenario, defending their surveillance programs in open court. What's coming? Friday, August 15th, 12 p.m. Emergency hearing on the 12 other tech cases using CyberTrace surveillance. 3 possible outcomes. Judge grants DOJ time to prove surveillance. Legal cases continue, but delayed. Judge dismisses cases with prejudice, like TechCore. All 12 companies walk. Judge allows evidentiary hearings case by case months of litigation. Former federal prosecutor says outcome 2, most likely, because precedent is set if method was unconstitutional for TechCore, it's unconstitutional for everyone. Also scheduled. Monday, August 18th, DOJ Inspector General announces scope of internal investigation. Wednesday, August 20th, FISA court holds rare public hearing on CyberTrace authorization, August 27th. Congressional hearing with AG. Kensington, Chen, FBI director, still unknown. Who leaked Kensington's memo to ProPublica? Whether Kensington herself authorized the leak or if someone else inside DOJ did it. What the classified FISA court opinions actually say about CyberTrace surveillance, those are still sealed. Whether criminal charges will be filed against prosecutors or FBI agents for Fourth Amendment violations. The Friday hearing determines whether this is isolated TechCore victory or wholesale collapse of DOJ's big tech enforcement strategy, 43 hours from now. If those 12 cases get dismissed, that's $340 billion in potential fines eliminated. 3 years of investigation wasted congressional fury at DOJ leadership. Possible criminal referrals for prosecutors. Legal experts are watching FISA court hearing on August 20th most closely. If FISA court publicly admits CyberTrace authorizations were overly broad, that's federal judiciary rebuking intelligence community. Hasn't happened since Church Committee in 1970s. This could force complete overhaul of digital surveillance legal framework. Privacy advocates are calling this the biggest Fourth Amendment victory in the digital age. DOJ is calling it a technicality that lets monopolies escape accountability. Either way, the memo that leaked Wednesday changed everything. One senior attorney's documented warnings ignored for months, then exposed to public. That's how institutions get checked. Subscribe. I'll break down what happens at Friday's emergency hearing. That's where we are. TechCore. 3-year prosecution collapsed in minutes based on leaked internal DOJ memo exposing 18 months of warrantless surveillance. Surface read. Tech company gets off on technicality, but this exposed systematic Fourth Amendment violations across FBI's entire big tech investigation program, with 12 additional cases now in jeopardy and congressional investigation launched. Friday's hearing determines whether DOJ's entire antitrust enforcement strategy survives. Stories moving. Subscribe for the breakdown when Friday's emergency hearing concludes. I read the documents, so you don't have to. 23 pages of Rachel Kensington's memo. Every warrant defect. Every date she warned leadership. Every case now compromised. All documented in Appendix A through C. Plus, Judge Blackwell's 34-page dismissal order. The sealed supplemental opinion. The docket entries showing what's coming. Friday, noon Eastern. Federal Courthouse, District of Columbia. 12 tech companies, 12 cases, 1 surveillance method. Judge has 3 choices: delay, dismiss, or litigate. 43 hours, more coming.